Jeffer.
Thank you very much, Chair, and thank you, Minister, for appearing in front of us and giving us a detailed explanation. My colleague, Senator Baker, asked you a question, and I may have missed the answer. Did you say that your department had looked at the constitutionality of this act and it was charter compliant?
We have considered the legality of it, and I am convinced that the proposal is constitutionally compliant.
I also want to talk about the identity issue. I'm very concerned about this issue. You have said about photo ID and not needing photo ID, and I'm happy you've said that. But did you say that one piece of ID would have to have an address?
Yes, you have two options under the Fair Elections Act. One is to provide a government-issued photo ID, or to choose any two of 39, one of which must have an address.
So I have two questions. I must start one with the issue of Aboriginal people. I understand that the Indian status card does not have an address. And Peter Tinsdale, acting CEO of the Assembly of First Nations, has testified that the changes will make it harder for Aboriginals to vote and is a step backward. I hear you, Minister, and this debate has been going on about identification. For me, what's important is, once this bill is passed, how are we going to make sure that Aboriginal people who do not have an address on their reserve, what are you going to put in place so that they can vote?
Under the existing list, there is the attestation of residence issued by the responsible authority of a First Nations band or reserve, which would be yet another option. And that would assume that the voter in question did not have any utility bills, any bank card, any vehicle ownership insurance, any correspondence from a university, any statement of government benefits, any government check whatsoever, any pension plan statement of benefits contribution, no residential lease or mortgage, no income or property tax assessment, which in that case wouldn't apply, of course, no insurance policy. Like, if you have none of those things, you can still seek a letter of attestation from your First Nations band or reserve.
Minister, the reality is that some Aboriginal people have no home address. It doesn't exist. What I'm saying to you, and I leave this with you because you obviously have to reflect on it, is how are you going to make it possible for them to vote? They do not have a home address. According to the Chief Electoral Officer, Mark Maynard, this bill will affect between 100,000 to 120,000 people, including students who might not have ID with their current address. And I've already said First Nations people living on reserves who do not typically have a residential address. What are your plans to make sure that each Canadian, when they don't have an ID and don't have an address, consider they're homeless, they don't have an address, how are they going to vote? You know, when I was a young lawyer, I used to go on election day to help the homeless to be able to go and vote. They didn't have an address because, as you know, you go in the evening to a place, it can be a different place every day. It's not your home address. And then the next day you go to another place. How is that person going to be able to vote?
You ask a very good question. It's one that Senator Pierre Nolan asked Minister Van Loan when he came here in 2007. The reality is that for the purposes of an election, a homeless person is considered to reside in the place where they either spend their nights or take their meals, generally speaking. So if they, for example, return to a soup kitchen daily for their meals or to a shelter nightly or sporadically, that is considered to be where they reside for the purposes of casting their ballot. That is why the existing list of 39 contains the possibility that a soup kitchen or a homeless shelter can issue a letter of attestation as to that person's residence at the kitchen or the shelter in question. But I'll just remind you one thing here. This issue of people who do not have a fixed residence is not resolved by vouching, because at some point you have to determine where the person calls home. Just because it's done by spoken word does not mean that it is any easier or more accessible than if it is done by the written word of an authority that provides services to that person.
Minister, every few months, I walk on the streets of Vancouver in the middle of the night. And I see the same people sleeping in the same corner month after month. That's their home. They don't have an address, but somebody that works with them or sleeps next to them says that that's their address. That's where they live, in that particular area. That person now, under this new law, will have no address and will not be able to vote. Is that the kind of democratic reform we want?
That's not true. The existence or non-existence of that person's address has nothing to do with the provision of vouching. At the end of the day, the Act already requires that you establish some sort of residence in order to cast your ballot. That is not changing in the Fair Elections Act. What is changing is the way you establish it. The Fair Elections Act requires that some ID be presented, and it provides 39 different ways that that can occur, including very thoughtful examples that help people who do not have a fixed address.
Minister, thank you very much for being here today and for, I think, your first appearance before the Legal Affairs Committee. The first question I want to ask you about, I come from Saskatchewan, and many Aboriginal people, of course, reside in Saskatchewan, and if you could, I would like you to explain the attestation of residence issued by a responsible authority of a First Nations band or reserve, being one of the ways that Aboriginal people would be able to show address.
Yes, so for those Aboriginals who might not have photo identification or government-issued ID, who do not receive any correspondence from the government in the way of assistance programs, they have the other alternative, which is an attestation from a responsible authority on a First Nations band or reserve. The interesting thing about this is that responsible authority can provide multiple letters, whereas that authority, if that authority existed in the hands of one person, could only vouch for one. So if, for example, there were multiple people on a reserve who did not have government ID, they would find this provision far more useful as a form of identifying their residence than they would vouching. I think that it provides a very reasonable method by which people can establish where they live and by which the authority on the reserve can do so. Now, these do not have to be complicated missives. They don't have to be, it doesn't have to be a novel. It's simply provide a written statement that who the person is and where they live will suffice.
Thank you. Yeah, in my view, you should have to have at least as much ID to vote as you do to take out a library book or rent a movie, should movie rental stores still exist. But as well, there are very few provinces in Canada that allow vouching for provincial elections. And I'm wondering if you could comment on that.
Well, I mean, look, every province has its own form of requirement to determine someone's residence and establish their identity. And you're quite right, there are many provinces that do not permit vouching. To my knowledge, none of those provinces have been found to have violated the Constitution by mere fact that they don't have vouching.
And dealing with the Director of Public Prosecutions, in your opening statement you referred to it as astounding that some have now questioned the independence of that particular officer, and I certainly agree with you on that. In my past experience as the Chief of Staff to Saskatchewan's Justice Minister, this was a very important position dealing with the Ministry of Justice, and although that position for Saskatchewan technically reports to the Minister of Justice, independence is a vital and well-respected tenet of that office from the Minister's office. It's one of the most important initial briefings that you receive in that Minister's office is the independence of the Director of Public Prosecutions. And I'm wondering if you could just expand on what you said about that particular independence of that position a little further.
Well, to start with, anybody who takes the position that the Director of Public Prosecutions is not independent has a big problem with the existing Canada Elections Act. Because under the Act today, there is no offense that can be prosecuted without going through that the Director of Public Prosecutions. He's already in charge of that. In the 7 years he has held that role, I have never heard a single suggestion that he has lacked independence in the way he's done this job. I'm not aware of any statement by Elections Canada suggesting that he has lacked independence or that there has been political interference in the work that he has done. In fact, I've never even seen an allegation, proven or otherwise, to that effect. It is only since we have suggested that the Commissioner be situated in the office of the DPP that suddenly Elections Canada and its spokespeople have questioned the independence of that officer. And that is really an extraordinary thing coming from an agency that only in its 2012-13 annual report called him an independent prosecutor. The word independent was the adjective that Elections Canada chose in its own annual report to describe this person. And now it's the agency has performed a 180-degree reversal, which really raises a lot of questions about Elections Canada and the degree to which it is prepared to change its positions now in order to defend its control over this function.
Thank you.